we're going to try to get started here, so if we can go on the air. I think we're on the air now. This is being recorded so that if somebody couldn't make it to this meeting, they'll be able to watch it on our website. So, good afternoon. My name is Laurie Cohen. I am the village attorney, and I want to introduce our assistant village attorney, Rachel Bosch. Rachel grew up in Wellington, so she's very familiar with the village, and we're happy to have her in the legal department. I want to thank you for coming because your service as a board or committee member is extremely important to the village. The council members rely on you, on your advice in making decisions, and so it's important. Your role is important. It's appreciated. And we want you, the legal department especially, wants you to feel free if you have any questions about your role or, public records or sunshine or ethics to, give us a call, and we'll be happy to talk with you. We're going to go through several topics. Many of you are longtime board members and so have been through this before, and I apologize if it's repeat, but it's always good to refresh your recollection and your memory about some of these issues. But we're going to go through ethics, public records, sunshine, quasi-judicial hearings, and we're going to touch briefly on Robert's Rules of Order. We're going to do first, we're going to do the ethics and the public records and sunshine. Some of you serve on boards that hear quasi-judicial matters, and therefore, we'll probably save that one for last. Did you have a question, Tom?
No, I did not.
Okay. Good. So this is pretty informal, and it's intended to be informative. And so if during the presentation you have any questions, go ahead and raise your hand. Because it is being recorded, we're going to go ahead and give you a microphone if you do have a question, so that whoever is listening to it or viewing it later can actually hear the question that's being asked. Okay? So the first thing we're going to talk about is ethics. And as a board or committee member, you are bound by both the Palm Beach County Code of Ethics and the Florida Ethics Code. Okay? So there are different core functions. Let's just talk about Palm Beach County. There are different core functions that kind of comprise the realm of ethics. You have the Commission on Ethics, which, as you know, was formed a number of years ago after we had some issues in Palm Beach County, and it was approved by the voters. And what they do is they investigate complaints that are made against either elected or appointed officials, and you all are considered appointed officials. They issue advisory opinions. So, for example, if you have a question about some future conduct that you are contemplating and you're not sure whether it violates the ethics code, and if I don't know the answer or if there's no published ethics opinion on it, we can go to the Ethics Commission and we can ask them to give us an advisory opinion. And so I encourage you, if you think that there could be an issue that's coming up, identify it early, and in the event we need to obtain an ethics opinion or advisory opinion, we'll have time to do that. And then, of course, they also do training and outreach. They'll come out to the village periodically, and they will train both staff and board and committee members and council members on, their various responsibilities as elected and appointed officials. Then you have the Office of the Inspector General. So that office is really charged with, ferreting out government waste and reviewing contracts and making sure that there's no, abuse of the government power to contract and to award contracts, and making sure that there's no mismanagement. And so, we partner with both the Commission on Ethics and with the Inspector General. We're very cooperative with them. We try to be proactive with them. And it is always the village's intention to do what's best for the taxpayers. And so if we have questions, we'll, if there's some issue, sometimes we'll self-report, or we'll contact the IG, or we'll contact the Commission on Ethics and work cooperatively with them. And of course, we also have the State Attorney's Office, and so if there's some investigation of a complaint and it arises to a level that constitutes potential criminal conduct, the Ethics Commission or the IG can actually refer that matter over to the State Attorney's Office. We hope that that doesn't happen, and we're here to help avoid those types of issues. But ultimately, if conduct appears to violate a criminal statute, it could be referred to the State Attorney's Office. And this is not intended in any way to scare you. It's just to remind you that, you do have some particular responsibilities as appointed and, board and committee members. So the Code of Ethics is comprised of a number of sections. One of them is conflict of interest, and we're going to go through these in a little bit more detail. One of them is conflict of interest, and then there's misuse of office for financial gain, and then there's the gift law. And so, I think as we go through them, you'll have a little bit better understanding of what is prohibited. The gift law limits, gifts that you can accept from various members of the community. It prohibits gifts for certain reasons or from certain individuals, and it contains reporting requirements. And so, for example, and this will be touched on again later, if it's a vendor or a lobbyist or the principal or employer of a vendor or lobbyist to the village, there is a annual limitation of $100 on the amount of a gift that you can accept from that individual or that corporate entity, that corporation. And so that is intended to prevent board members and committee members who have the power to approve various things from being improperly influenced by those vendors and lobbyists and principals of vendors and lobbyists. Okay? So under the Code of Ethics, there are two standards. One is the minimum legal standard for violating the code. And so, the code sets out the floor, basically. And if you violate the minimum standards under the Code of Ethics, then, you could be, receive a letter of instruction, or there could be a finding of probable cause, or some other disciplinary type action. But then you also have to be concerned about the appearance of impropriety. So, for example, you may be on a board or committee with people that you know well, and you may be sitting in a social setting, perhaps 3 or 4 of your committee members. You may be talking about something that has nothing to do with village business, and people may see you gathered together and may just assume that you're violating sunshine or doing something improper. And this is not to say that you can't ever get together or talk with your fellow board or committee members, but be aware that in addition to the actual violation of the minimum legal standards, you have to be concerned about the appearance of impropriety. So when you're considering your own personal conduct, we've kind of come up with this number of questions. Ask yourself if it's legal. Does it comply with the Code of Ethics? Does it comply with your board procedures and Wellington policies? And would it pass the Palm Beach Post test? In other words, would you like to be reading about it in the Palm Beach Post? And so, that kind of should govern how you conduct yourself in your role. So this is an example of misuse of office, or an exercise to kind of think through whether it's misuse of office. You have a code inspector. The officer is assigned to inspect the property owned by his sister. So can the code officer inspect it? Yes, of course. But should he? And the answer is no, because even though he may not treat his sister differently from anybody else, it's the appearance of impropriety that could potentially lead to a complaint. Now, here's another example or to think through. An elected official serves on the board of a nonprofit organization. Or when I say elected official, I'm also talking about appointed board and committee members. So let's say, for example, you are a board member of a nonprofit organization, and there is an issue that is coming before your board or committee for Wellington that could have a benefit to the board, the other outside board that you serve on. Can you vote to give government funding to that nonprofit? And right, the answer is no, because the Code of Ethics and the opinions interpreting the code say that you cannot use your position as an appointed board or committee member to benefit another board of which you are also a director, okay, or a member. Now, if you're just a member of the organization, let's say you're on the Parks and Rec board and you happen to be a member of one of the chambers, and something comes before your board that would benefit the chamber. If you're not a board member of the chamber, if you're not an officer or director of the chamber, that's not going to be a conflict. The conflict arises only when you are a board member on both boards, and the service on a Wellington board benefits another board of which you are an officer or director. Now, in addition, there are some limitations on what you can do to solicit for charitable organizations. So, for example, that same kind of rule applies. If you're on the board of the charitable organization and you're soliciting for charitable donations, you're not going to be able to solicit from vendors, lobbyists, or principals of lobbyists, principals or employers of lobbyists. You may solicit from other people, but the Code of Ethics would require you to keep a particular log, and those logs can be found, those forms can be found on the code, on the Palm Beach County Commission on Ethics website. But again, if you ever have a question about any of these things, you should pick up the phone and call us, okay? Also, again, you can use your title in the solicitation, but there are limitations on that, and so you'll need to be careful about doing so. Sometimes people want to have celebrity bartender nights and things like that. Just be aware of those types of things and either take a look at the Code of Ethics or give us a call and we'll help you think it through, okay? This actually is based on an actual case that was considered. This is where an elected official is driving to work and gets cut off by an irresponsible driver. And the official confronts the driver, who decides to call the police. The official encourages the driver to call, stating, "It's fine, I own the police." So that would be a corrupt misuse of your official position. You can't use because even though there was no money changing hands or anything like that, if there is some special financial benefit, for example, if you're using your position to get out of getting a ticket, that could be construed as a special financial benefit. So that would be improper. You can't use your official position to derive a special financial benefit personally. Now there are exceptions to that, and let me give you an example. Let's say you're voting on an issue that affects the community in which you live, the development in which you live. I'm gonna pick on Olympia. Let's say there's an item that would have some special benefit to all of the people who live in Olympia. The Code of Ethics says that if the group of people impacted is sufficiently large enough, in other words, if the financial benefit that you would gain by that vote is diluted enough by the large pool of people who would similarly benefit, that would not constitute a conflict. But let's say you're voting on a matter where there are only maybe 15 homes in the community. The code says that anything less than $100 is probably going to be a special financial benefit to you, okay? So again, if it's something that's impacting your community, think about it, be aware of it, take a look at the code, give us a call, okay? So the code prohibits contracts between Wellington and you personally, or your outside employer, or any business you or a household member may own in combination. So if you own more than 5% of the business in combination, then that would be prohibited. There are some exceptions. And let's get my little cheat sheet here. This is what the code says the exceptions are. It says that this prohibition on awarding a contract, a contract between you and the village, shall not apply to employees who enter into contracts with Palm Beach County or a municipality as part of their official duties with the county or the municipality. The prohibition also shall not apply to officials or employees who purchase goods from the county or municipality on the same terms available to all members of the public. And the prohibition shall also not apply to advisory board members provided the subject contract or transaction is disclosed at a duly noticed public meeting of the governing body, and the advisory board members board provides no regulation, oversight, management, or policy setting recommendations regarding the subject contract or transaction. Now, I would argue that the language of this, advisory board, you may want to investigate whether that includes boards that have final decision-making authority. Some boards have final decision-making authority. Planning and zoning, Parks and Rec, considering the sales tax, how that money is going to be spent. The tree board can actually have final decision-making authority in some instances. There are a number of ARB. So again, have to be careful about that. Okay. Any questions so far? Okay. Yes, hold on, Howard, let me get you the microphone so that we can capture your question.
Thank you. The question was on the last slide. You had the Senior Advisory Board. May I ask what that refers to, please?
These were just examples of boards that were, where you might be able to have a contract, but it would have to meet the requirements that I read to you from the ethics code. It was just intended to be an example,
Okay.
not singling you out.
Thank you.
Okay. Okay, so the next part of the ethics code that we want to talk about is the gift law. And again, there is an absolute prohibition against taking a kickback or a bribe, because that would be illegal and criminal, or taking tips of any kind in exchange for a vote, okay? So you can't sell your vote, you can't receive some financial benefit based on how you intend to vote, okay? Now, the other class of limitations that the gift law imposes is when you are accepting a gift from a vendor, a lobbyist, you know, a bidder or proposer, or the principal or employer of a lobbyist, okay? So there may be times when you're, you know, you're out, you're meeting with someone about something that's going to come before your board, and they want to buy you a cup of coffee. There's no prohibition against accepting that, as long as the value of gifts you accept from that entity or person does not exceed $100 in the year, okay, during the reporting year, okay? Some of you are what we call reporting individuals under the Florida ethics rules. And if you're a reporting individual, so for example, if you're on planning and zoning, and I'll have to double check, but I believe planning and zoning, possibly ARB, construction board, possibly are reporting individuals. If you're curious about that, I'll look it up later. I don't have the answer off the top of my head. But some of you are called reporting individuals, and you have an obligation to file a gift report on a quarterly basis. So if you accept a gift in excess of $100, you know, either obviously it wouldn't be from a lobbyist or vendor or you know, principal or employer of a lobbyist, because that's prohibited. But let's say it's not any of those, and somebody gives you, you know, tickets to an event, or travel expenses, or does something nice for you or your family, then that has to be reported if you're a reporting individual, okay? Ernie, hang on, let's get the microphone to you.
I have two questions. The first one is, how do you turn the mic on? If you have lunch or dinner with employees at a village, and sometimes you split the bill, sometimes you pay one time, they pay the other time, does that fall into any of this?
Well, I would say that accepting a gift from anyone, if you're
Is that a gift? I mean,
hang on. Okay. If they pay for your, you know, dinner at, you know, the Breakers or something, and it exceeds $100, and you're a reporting individual, then you should disclose it.
all right, second question, the village does meetings once or twice a month where they provide lunch to whoever shows up. Does that fall into any category?
No, because when the village itself is providing the benefit to the board or committee members, I believe there's an exception under the code for that type of a thing.
Okay.
Okay. Also, your friends and your family gifts from your friends and your family are not included within this reporting requirement.
That was the question I was about to ask. The definition of anyone that excludes
Your
friends,
and your
family.
Yes, there is a particular definition of that under the code. And so, you know, primarily it's going to be your family members and, you know, very close friends. But you would want to look at the definition of what constitutes, you know, family and friends.
How do you distinguish between, you know, you could have a business associate who's kind of a friend, and you also do business with that individual. Do you err on the side of caution
I would
and
err
just
on the side
report
of
it?
caution. Absolutely, I would always err on the side of caution because there's no penalty for disclosing. there could be a penalty for not disclosing. And so it's better to disclose, to over disclose than to under disclose. Okay? Did I get to the end of I think I got to the end. Okay. So that is kind of what we wanted to cover with respect to ethics. And Rachel is going to talk with you about sunshine and public records. And let me see how we bring that up here. Okay.
From the beginning. Oh, even better. Thank you. Hi, everybody. Once again, I'm Rachel Bosch, and I'm going to be talking to you about Sunshine Law and also about public records. So we have this concept of open government, and there are two parts to that. One part is open meetings, which falls under the Sunshine Law. And the other part is public records, and I'm going to talk to you a little bit about each of those, starting with the Sunshine Law. So the Sunshine Law sort of originated because the press was concerned about backroom deals and wanting to know more about the process in terms of how and why decisions are made, not just what those decisions are. And so in the case of Times Publishing versus Williams, the court said it is how and why the officials decided to so act which interests the public, not merely the final decision. So we have this concept of politics in the sunshine, open meetings, so that the public can know the process behind why the decisions that we're making are made. And that's rooted in Article 1, Section 24 of the Florida Constitution, and also in Section 286.011 of the Florida statutes. When you're looking at the Sunshine Law, there are three basic requirements. The first is that meetings of public boards or commissions must be open to the public. We also must provide reasonable notice of these meetings, and minutes of the meetings must be taken, properly recorded, and open to public inspection. With respect to the third requirement, the meeting minutes, that's not really something that you need to worry about. At your meetings, there will be a staff liaison present, there will be a representative from the clerk's office present, and the representative from the clerk's office is going to take the minutes and record them and make sure that they're available for public inspection. But what you really need to be concerned about is that the meetings would be open to the public, and also that we have to provide reasonable notice of any meeting. Reasonable notice is not defined in the statute, but our charter specifies that we have to provide 72 hours in advance of any meeting that's going to be held. And again, all of this goes to this notion that any communications or deliberations of your advisory board needs to be conducted in the sunshine, in the public. So advisory boards created pursuant to law or ordinance or otherwise established by public agencies are subject to the Sunshine Law. And any action taken by your advisory board, and this includes discussion and recommendations that are made to council, has to be done in the sunshine. So basically, any action that you are taking in your capacity as a member of an advisory board has to be discussed out in the open. And communications include emails. I'm a little behind on my slide. Emails, telephone conversations, text messages, any kind of social media discussions. Anything that's reasonably likely to come before you as a member of a board or committee has to be discussed out in the open. So we would discourage you from using your personal devices to have any discussions about public business. And I'm going to talk more about public records later, but you're kind of opening the door and doing that to a public records issue, because if you are talking about public business on your personal device, you are potentially creating a public record, but additionally, you can be opening yourself up to a sunshine law violation because you can't be having communications about any matter that's reasonably likely to come before you as a member of your board with other members of your board. So for example, if you post something on Facebook about public business, which again we would discourage you from doing, it's not necessarily the posting per se that's a problem, but when people start to comment on those things, or if a group email is sent and you're kind of opening yourself up for a reply, and now we're having this discussion back and forth potentially between board members about something that's supposed to come before you, and now we have a sunshine law violation. If you need to communicate something, we encourage you to talk with your staff liaison. Each committee and board has a staff liaison. However, you can't use your staff liaison to sort of indirectly do things that you're otherwise not allowed to do. So you can't use your staff liaison as an intermediary to have communications with other members of your board about issues that might come before your board, because you're not allowed to talk to them directly, you're not allowed to talk to them indirectly. You know, you can't ask a staff member to poll other members of the board to kind of feel out what their position is going to be on a particular issue, because again, it's going to be a sunshine violation. You could ask staff, however, to, for example, distribute an article or some factual information that potentially relates to an issue that's coming before your board, but you can't ask staff to, you know, distribute your opinion on that particular issue. In fact, it would have to be something that's fact-based. Another thing that you should consider is that when you're sitting at a meeting on the dais, you can't have private conversations with other members of the board that are not spoken into the microphone and that are not communicated to everybody who's in attendance, because even if you weren't communicating about an issue and it's just some side conversation, you're opening yourself up to a sunshine violation. And so anything that's discussed during that meeting needs to be done so that everyone who's in attendance can hear what you're talking about. Oh, we have a question.
I just want to say to mention the fact that if you get it emailed and you reply, never push reply all, because that would be a problem.
That's an excellent point, and we highly discourage sending an email to your other board and committee members, because it is just too easy for somebody to forget and reply to all, and then you've got a sunshine issue.
So part of the reason why we're talking about sunshine issues is because there are penalties for sunshine violations. So for a knowing violation of sunshine law, a person is guilty of a misdemeanor of the 2nd degree. So if you knowingly violate. If there's an unknowing violation, there's still a penalty for that as well. It can be prosecuted as a non-criminal infraction, resulting in a fine up to $500. Are there any questions about sunshine before I move on to public records? Okay. So the next component of open government is public records law, which comes under Chapter 119 of the Florida statutes. And specifically, public records are defined in Section 119.011. And I have the definition up there for you, but public records means all documents, papers, letters, maps, and there's a long list there. But what's important is that it's made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. So again, if you can use your, if you're having a text back and forth with a neighbor, or an email back and forth with a neighbor about, dinner plans or something that you're doing with your kids this weekend, that's not a problem. But if you're talking to that same neighbor about village business or something that may reasonably become before you, you are now creating a public record. And that's why when I talked earlier that we discourage you from using your personal devices for having these kinds of communications or any kinds of communications about public business, because once you've created a public record, the village has obligations to produce public records if they are requested, and there are penalties for us not following that law. Additionally, you could be subjecting, and I'm going to get into this a little bit more later, but you could be subjecting your personal device to inspection if there's reason to believe that there are public records on there.
And I want to stress something, that it is your responsibility to preserve the public record. If, for whatever reason, a public record is created, it's your responsibility to preserve it. And I would say in that instance that you should probably just go ahead and forward the email, or take a picture of the text and print it out and send it to the village clerk so that we have it and it just can't become a problem. Okay?
So just to reiterate, all materials made or received by the village in connection with official business that communicates or formalizes knowledge. So there's a list there of things that this could include: agendas, emails, utility bills, permit applications, code violations, our Wellington Facebook page, or any other kind of Wellington social media. So if you're using your, for example, personal Facebook page or personal other social media page to disseminate information about public business, you're now creating a public record. Not to mention also, if people comment on that, now we're getting into the Sunshine Law issue, which is why we really discourage you from doing that. Some things that would not be included as a public record would be physical specimens, because that can't be reproduced, and one of the requirements for a public record is that it can be copied. And then notes created solely for your personal use. So you can take notes, in your capacity as a board member and on things relating to your work as a board member, as long as they are made for your own use and not disseminated to anybody else.
Mary Jo?
Going back to posting on Facebook or social media, being part of Parks and Rec, we like to post what's going on in the village. It's not crossing the line if we post it on our personal Facebook page, but we have to be leery of the comments. How is that
Here's
handled?
the thing. If you're posting stuff on we have a Parks and Rec Facebook page, okay, and other social media. If you're posting on your personal page about village business, then it is deemed a public record. So you have an obligation to preserve that public record. Now, the posting by itself, there's no problem with that, so long as you preserve it. But what happens is, people may start to comment. You have to preserve the comments, can't delete them. And where you might run into trouble is if a fellow board member actually posts a comment in response, if it's something that you may be, voting on, or that's going to come before you. So that's where you could actually run into trouble. And that's why we discourage it. And that's why the village actually maintains these, social media pages, because we have the ability to monitor it. We have a software program that preserves it. And we know that we can capture all of this public record information in the event there's ever a request for it. So I highly discourage you from using your personal Facebook, Twitter, any of that for disseminating Village of Wellington business.
So when you're considering whether something is a public record, you want to ask yourself these three questions. Was it prepared or received by a government or an agent of the government? Is it something that can be copied? And was it created in order to perpetuate, communicate, or formalize knowledge of some type? And if the answer to those questions is yes, then it probably is a public record. And again, this includes emails, text messages, and official Facebook or other social media pages. One thing for you to consider, or for you to take into account, while we want you to understand that you potentially could be creating public records, it's not It's your obligation to preserve any public records that you create, but in terms of responding to public records requests, that's something that we handle here through our clerk's office. So a custodian of public records means the elected or appointed state, county, or municipal officer charged with the responsibility of maintaining the office having public records, or his or her designee. So you are not actually going to be responding to a public records request or called on to respond to a public records request. However, if it's something that concerns you, we, maybe communications with you about a particular matter, we, in addition to looking at what we have in our possession, we may reach out to you to see what you have in yours. But also, if you're at a meeting, a public records request doesn't have to be made in writing. It can be made orally. And so maybe somebody attending your particular meeting asks you for a copy of a particular agenda item. If you have the copy, you can certainly give that to them, or you can ask your staff liaison to make a copy of it so that you can provide it to the person who's requesting it. There's no problem with that, and we would encourage you to go ahead and do that. In terms of our obligations in responding to public records requests, we have to, and again, this is the village's responsibility. I'm just sharing it with you so that you generally understand the way public records requests work. We have to promptly acknowledge the request and respond in good faith, and also within a reasonable amount of time. There's not a particular statutory definition as to how much time we have to respond to a request, but we have to make a good faith attempt to provide the documents. The most important thing to recognize about public records, or one of the most important things, is that the request can be made by anyone. They don't have to live in the village, they don't have to live in the state of Florida, they don't have to tell us who they are, it doesn't have to be in writing. If we get the request, our obligation is to acknowledge it, respond in good faith within a reasonable amount of time. And we can't put any conditions on the response. So for example, we can't ask for it to be in writing. We can't even ask who the person is. If someone makes a public records request anonymously and we have the ability to respond, we have to go ahead and do that.
Don't they have to pay?
Okay, the question was from Ernie, don't they have to pay? It depends. We have a policy in place as to when, at what point we will charge for making either copies of records or for the staff time incurred in gathering those documents. And so yes, there are times when we will ask the requester to pay for the documents. And certainly we can ask for as much information as we need in order to communicate that to them and to be able to provide them with the actual records.
So this next slide talks about exemptions to the public records rule, and that's found under section 119.017 of the Florida statutes. This is really not pertinent for your purposes, again, because you're not going to be the one that's responding to the request, but it's really just to make you aware that there are some exemptions to what information we have to provide. And again, if a public records request was directed to you or something that's involving you, we would reach out to you on that, and our clerk's office would handle, for example, redacting any information that we're not obligated to provide or not allowed to provide. Does anyone have any questions?
I want to just kind of go off script here for a second and talk about a couple things that have to do with public meetings and that sort of thing. I mean, first of all, Wellington prides itself on being open government and being, wanting to hear from its constituents and other interested people. And so when you're having your meetings, we want you to give people the time that they, are entitled to express their opinions. Under the open meetings law, the public has a right to be heard. They don't necessarily have a right to be heard at every single meeting, but that has to do with a particular item. But they have to be given the right to be heard at some point in the decision-making process prior to it becoming a final decision. So sometimes, you're going to have public comment during your board meetings, and, people may comment or they may not. Sometimes you're going to have like a workshop setting in which you're not actually going to be taking public comment because you're not making any final determination. And also, if you're an advisory board, that decision is actually going to be, you may be advising another board or you may be advising council, but that decision ultimately is going to be made by council. Now, we want you to allow the public to be heard, unless it's like a workshop setting in which that type of thing would be disruptive. We also want you to be able to control your meetings. If you're the chair of your committee, you have to control your meetings. You have business that has to get done. You have to move through your agenda, and you can't let the public, get you off on a tangent or disrupt your meeting. And so therefore, if the public, if someone is standing at the podium and shouting and, using profanity and all kinds of things, you have the ability to put a stop to it. You can ask them to sit down, you can bang the gavel. If it persists, and if there's, an officer present or something, you can actually request that person be removed. That is a last resort, okay? But it is possible that you could have to do that. I've been at a number of meetings where it's been a very contentious issue, and people are passionate about their opinions, and when it affects their property values, they really take it to heart. And sometimes it can get a little dicey, and I've had to call PBSO right in the middle of a meeting and say, I need somebody here right now. And so that doesn't happen often, and I'm not saying that you should use that tool, but it is a tool that you have as a last resort if someone is getting extremely disruptive or threatening, or you feel that there is some risk there. Okay. Now, the other thing I wanted to touch upon is, and I forgot to mention this at the beginning, some of your boards are created by Florida statute, and we're required to have them by Florida statute, but most of them are created by either ordinance or resolution adopted by council. And in our code, your board or committee is only supposed to meet quarterly. Now, if there's some reason for you to meet more than that, then you will meet more often, and you can meet more often. But the general rule is that you should only be meeting quarterly. So I just wanted to make sure everybody's aware of that. Okay, Sam has a question. Let me give you the microphone.
Can you make the distinction between an advisory board and an advisory council?
Well, we don't really have any advisory councils here in Wellington. We have advisory boards and we have committees, okay? So, for example, advisory boards are typically non-final decision-making bodies who make recommendations either to another board or committee or to the village council, okay? And those are typically created by resolution. And usually those boards have no final decision-making authority. We also have boards that have final decision-making authority, such as Architectural Review Board, Construction Board of Adjustment and Appeals. Believe it or not, the Tree Board actually has some final decision-making authority if somebody challenges the tree, I've forgotten, I wrote it down, I was so surprised to see it, that, a violation of, under our tree protection. Planning and zoning, parks and recreation now with respect to the use of the sales tax money. So those boards have final decision-making authority. And sometimes if your board or committee is asked to be a selection committee for a particular purchase or contract, that the village is doing, then you're going to be recommending that to, you won't be a final decision-making body, but you might be recommending that to council. So there could be times when you're not just functioning as your advisory board or your committee, but actually playing a different role in assisting the village. Okay?
I serve in the Equestrian Preserve Committee. It's a volunteer. We are elected, but we are volunteers. If by any chance, while we're here, we make a mistake and we are sued, are we protected? Okay.
Yes, the answer is yes. We want to encourage people to serve on our committees, okay? We don't want you to be discouraged. And so the village not only carries insurance for that purpose, we also have, as part of our code, provisions where we can reimburse you if, for example, there's an allegation of sunshine violation. Council has also adopted a reimbursement policy that could apply to reimburse you for legal expenses associated with successfully defending an ethics complaint, okay? Now, there are certain parameters. You have to meet with the village attorney. We have to go over things. There are certain guidelines. But certainly if there is some issue that arises, some complaint filed against you, the first thing you want to do is call our office and sit down with us, and we will walk you through what things are available to you. And you know, we're not looking to have you all exposed to financial loss as a result of your service on our boards or committees.
And this was brought up, what's the limit the village would cover? $1 million, $10,000? You know, what is the limit the village insures us for?
I don't know the exact limit off the top of my head. It probably would be a combination of the insurance policy, which has limits, and then, you know, for example, if it's a ethics issue, could be reimbursed under that reimbursement policy that council adopted. And there is also authority under the village code for certain types of violations to reimburse. And I would assume that council would reimburse the reasonable costs of that type of defense, but not, you know, exorbitant costs. I mean, certainly you're going to want to.
Sued for a large amount, for whatever reason. I don't expect it to happen, but is there a cap on the insurance policy?
Yes, and I don't know that off the top of my head. Okay. Did you have a question also? Okay. Anybody else have questions about ethics, public records, sunshine?
Lori, I have one.
Sure.
The village contracts with outside agencies, like the police department.
Yes.
What is the relationship as far as a committee member goes to that agency as opposed to the Village of Wellington? I mean, when they contract out there, for instance, public safety, what would the involvement, what would our obligation be if we deal outside with the police department and also as a committee member? In other words, if we hire police and you're on a board that uses police, is there any conflict there? Is anything?
You know, I don't think so. The police are operating as, you know, we're kind of subcontracting out our policing function, not totally our police powers, but our policing function to PBSO. And so if you're on an HOA board or something like that, and you also contract with PBSO, I don't believe that that poses any conflict. But, you know, certainly I could research that issue, and we can.
Wouldn't that also have to do with the scope of the committee you sit on? What?
Right, correct. So just off the top of my head, it doesn't seem to me that it would be a conflict. Okay.
Sorry, just sort of going back to what the gentlemen over there were worried about. Wouldn't any advisory board members acts as an advisory board member be covered under sovereign immunity, so they couldn't be sued personally for any decision they make or any act they take other than ethics?
Right. I mean, there is, qualified immunity for board and committee members as long if you're acting in the scope of your duties as a board member. Typically where this issue arises, though, is where there's an accusation that you've acted outside the scope and you've violated some code or some rule that prohibits what you've done. So that's where you run into trouble. I mean, there are many instances where, we have represented, PZAB comes to mind, where they have made a final determination on an appeal, for example, an appeal of a staff interpretation that has been taken to the circuit court on for a petition for certiorari. We prepare that defense. Now, they're not usually personally named, and so it's normally not a problem. I can't think of any instance in the time that I've been with the village, either as a council member or in my role as the attorney, where a board member was really personally named when acting in their official capacity. Right. It would be improper, and there is qualified immunity for that. Okay. Anything else? Okay. So yeah, I think we're going to move on to what was the last?
Robert's rules or
Yeah.
quasi-judicial.
I think we're going to move on to quasi-judicial matters. And for some of you, this really is not going to have a lot of application. But for others who hear these types of matters, it is. So I'm going to try to go through it quickly. There is information in your packet about handling those types of matters. But I think that it's just, kind of good for everybody to know. So, as I said, your role as a board member is providing advice to council. Some of you have quasi-judicial functions, EPC, construction board, PZAB, ARB, tree board, and those boards sometimes sit in what we call a quasi-judicial capacity. And that means that you're sitting not as a judge, but in a judge-like, position. So, as a board or committee member, you actually, you have legislative power. That's the power to make law or to recommend law. And that, would be the power to either make or alter or amend or repeal laws. Obviously, council ultimately has the power to make or repeal or amend the laws, but you're recommending to them that they do so. But then quasi-judicial is, acts of discretion of public administration, administrative officers or bodies who are required to investigate facts, ascertain the existence of facts, hold hearings, weigh evidence, draw conclusions from the evidence as a basis for their official action, and to exercise discretion that's of a judicial nature. Okay? So legislative actions are typically actions where it applies to everyone, as a general rule or policy. Quasi-judicial determinations are when you take that general rule and you apply it to a specific person or property or issue, okay? So it's the character of the hearing that determines whether the actions are legislative, which is policy making, or quasi-judicial, which is the application of that policy to a specific circumstance, okay? So if you're not sure whether it's legislative or quasi-judicial, then you need to ask yourself, was there a notice required in order to have the hearing? Is approval or denial contingent upon a showing made by the applicant at the hearing? And if so, then it's going to be a quasi-judicial matter, okay? So these are some actions that are typically quasi-judicial in nature: adoption of, legislative, comprehensive plans. Comprehensive plan, you may have heard that term before, that's our document that sets out the vision of Wellington, what we envision to be there. Adoption of the Land Development Code, adoption of our Code of Ordinances, and decisions relating to public expenditures. So those are all legislative in nature, and that is a very deferential type of standard. So, planning decisions are presumed to be valid as long as they're reasonably based on evidence presented. And board decisions on legislative matters are not going to be overturned typically unless they are clearly arbitrary or unreasonable. So it's very deferential to the board or committee or to the decision-making body. Oops. So here are some types of actions that are quasi-judicial in nature: site-specific rezonings, applications of the zoning code, zoning variances, special exceptions, development plans, master plans, compatibility determinations, site plan approvals, plat approvals. All of these are quasi-judicial in nature. I'm sure that you're all familiar with some of the very contentious matters that have come before council or EPC or PZAB, and they're applying that general code, general rule, general policy to a specific property. Okay? So, what are the requirements of a quasi-judicial hearing? You must afford the applicant procedural due process. Procedural due process means notice and an opportunity, a meaningful opportunity to be heard. Okay? You have to observe the essential requirements of the law. In other words, you can't make a decision that is based on, something that is just not applicable under the law. You can't depart from established law. And you have to base your decision on the competent, substantial evidence that's presented at the hearing. Okay? So, for example, the staff file becomes part of the record in the quasi-judicial proceeding. The staff analysis and testimony as to what is being presented. There will typically be an interested party and their testimony. There may be the applicant and their testimony. There may be an interested party who's either for or against the application, and that also is part of the evidence. Public comment can be part of this evidence as well. So procedural due process protects the integrity of the process and the fairness of the result. Reasonable notice of a quasi-judicial hearing is notice that's reasonably calculated and under all the circumstances to apprise the interested parties of the pendency of the action and afford them an opportunity to present their objections. And a fair and meaningful opportunity to be heard is also required, and that is the opportunity to present evidence, cross-examine witnesses, and be informed of all of the facts upon which the commission or board acts. Okay? So essentially what you want to do is give the applicant fundamental fairness. You have to base your decision on the evidence presented. You have to be judicial in your demeanor and free from prejudgment of the application. And this is something I want to stress for those people who are hearing quasi-judicial matters. A lot of times, developers or applicants are going to want to meet with you outside of the public hearing process. Florida law basically says that those are ex parte communications, meaning outside of the hearing process. They are presumed to be prejudicial. The presumption can be overcome by disclosing on the record at the hearing, the fact that you've met with, Mr. Jones or Mrs. Smith or whoever, and giving a summary of the substance of the communication, okay? So you have to maintain both the appearance and the reality of fairness. And that's why it's important in disclosing any ex parte communications that you've had outside of the hearing process, and remembering that it's not just actual, emails or telephone conversations or texts or anything like that that can be ex parte, but also site views. If you're invited to come view a site, you should be disclosing that prior to the actual hearing on the matter, okay? And so it has to be disclosed on the record. It has to be disclosed prior to the decision. We have a question. So.
Thank you very much. So you mentioned earlier that Wellington is interested in hearing from the citizens and the public. On this particular issue, it seems to me if you were to hear from the applicant and visit with the applicant before a hearing, then you have to divulge that conversation or meeting or whatever took place in the beginning of the meeting and under ex parte disclosures. It also seems to me that if you even met with that applicant, you should meet with the other side. And so where I've come to the point is don't meet with anybody because you can't make it fair. But is that not being open to?
Well, what I'm talking about is that public meetings should be open to, public comment. As a board member, and if you're hearing a quasi-judicial matter, you do not have to meet with the applicant. You do not have to meet with any other interested party. You don't even really have to meet with constituents. You can wait until the public hearing process and meet with them then. But if you choose to do so, okay, then you must disclose it. If you choose to meet with the applicant or an interested party or somebody who's, expressing their opinion to you one way or another, then you really must disclose that at the public meeting, and you must make an independent decision that is not influenced by that ex parte communication, because the applicant has a right to have the decision based on the evidence that's actually presented at the hearing itself, okay? And that's why it's presumed to be prejudicial, because it's presumed to influence you outside of the public hearing process. And the cure for that, which is not a perfect cure, but it's what the legislature has been able to fashion under the reality that developers want to meet with decision makers, is that if you disclose it and describe the substance of the discussion, then that rebuts the presumption. It doesn't mean that they can't ultimately challenge that if they wanted to take it to court and allege that there was bias or prejudice. But what it does is it rebuts the presumption. Okay?
Can I ask another question since I've got the microphone? In conducting the quasi-judicial hearings, right off the bat, you asked the board members to disclose ex parte communication. But this also says that you ask for views of the subject property. Can you elaborate on that?
That's what I was talking about site views. So for example, if you go out and look at the property, the way it's laid out or how they envision something being built, that site view is considered ex parte. It's outside of the public hearing process. So you should disclose the fact that you've gone to the site and you've looked at it. Okay? Oh, another question. Gail's falling asleep. I know. I've put you to sleep.
Thanks, Randy. If the village is having a function, and let's say there's a table, and several people are going to be at that table, you have to be careful not to form a quorum, because that would be a violation of Sunshine Law too, particularly if any particular committee has 4 or more people from that committee appear at that function and sit together.
Well, remember, you're not going to be discussing public business at that meeting, okay? And so if you're not discussing, I mean, at that social function. So if you're not discussing public business,
I mean, a village function, it's actually, you could have a table, and if there's a table there, and there's 3 or more members of the committee that are there, they will be discussing things, and that becomes a violation.
well, I'm not clear under what circumstances we'd have a table of board and committee members discussing things that was not publicly noticed.
At a health fair, for instance, and let's say there's a senior group there, and they're meeting, and they're explaining to the public about what they're doing, but they're with other members of that committee there. That would be a violation, I think.
It depends on whether you're talking about something that is coming before your board, okay? You know, in general, we're not going to be having a table of board and committee members talking about something that they're going to be voting on without publicly noticing that meeting, okay? So, you know, it's a good point, but it typically is not going to arise, okay? So again, the essential elements of the law prong of quasi-judicial hearings and due process requires that the decision be based on the controlling law, rules, and courts, statutes and constitutional law, and that the application of Wellington's code and land development regulations be properly applied. And so a ruling constitutes a departure from the essential requirements of the law when it amounts to a violation of a clearly established principle of law resulting in a miscarriage of justice. So, you know, a mistake by itself is not necessarily a departure from the essential requirements of the law. It has to be something that amounts to a miscarriage of justice. Okay? Competent substantial evidence is really just relevant evidence that a reasonable mind would accept as adequate. So, you know, that competent means kind of admissible in, would be admissible in a court, and substantial relates to the quantity of the evidence that is presented, okay? And under the standard of review on quasi-judicial decisions, if there's any evidence in the record that you could have relied on as a board or a committee member in support of your vote, then the circuit court must uphold your decision, okay? And so the decision has to be supported by evidence that's in the record. It can't be supported by things that are not in the record, all right? So here are some practical examples, opinions of professional planning staff. Does that constitute competent substantial evidence? Yes, absolutely, you can rely on that. The project file, again, yes, that is competent substantial evidence. Professional public comment on a particular matter, that, you know, somebody is an engineer or an architect or, you know, some other field, realtor or something of that sort, and they're giving you relevant comment on something that's before you, then yes, you can rely on that. Non-professional public comment that is just, you know, opposed to the application, you can only rely on if it's fact-based. So, you know, this general neighborhood opposition, we don't want this in our community, is not going to be competent substantial evidence. But if it's fact-based, we've seen, you know, increased traffic, increased noise, things like that. Our property values have decreased. Those types of things that are fact-based can be relied on. And then, of course, the argument of counsel representing the applicant, you know, is not going to be evidence. Now, many times the applicant will employ an agent, like a, you know, like a planner or a landscape architect or something of that sort. And typically they'll be sworn in and they are presenting evidence and testimony. But generally, if it's argument of an attorney, it is not competent substantial evidence, it's just argument, okay? And so you can't rely on their on their statements. Okay, so this is kind of a little technical, and I'm just going to really kind of breeze through this. Zoning and rezoning matters, there's some burden of proof that the applicants have. It varies depending on whether it's a zoning or a non-zoning matter. And then we have in our code, or in our council procedures, which apply to all of your boards and committees, we have laid out the process that you go through in actually hearing that matter. And if you are a chair of your particular board or committee, we have laminated copies for you to take and keep with you, so that when you're leading or when you're chairing a quasi-judicial hearing, you'll have this ready reference here. Okay? Any questions about quasi-judicial matters? Okay, Scott.
Lori, as it relates to the evidence issue, the formal rules of evidence generally don't apply in a quasi-judicial setting in terms of, for example, like hearsay.
Hearsay and things like that.
Is that
correct.
right?
I mean, if a reasonable person would rely on the evidence, then you can rely on it. In general, those formal types of evidentiary rules are not going to apply.
Thanks.
Any other questions? Okay. So our next thing that we're going to cover, oh, it's not. It's old school. We're just going to touch briefly on Robert's Rules, and I'll tell you why. First of all, Robert's Rules, the book is like this thick, and it really was never designed for small boards and committees. And as a practical matter, you're never going to use all the tools there. And the purpose of, having meeting procedures and meeting rules is really just to get the business of the village done. It's not to be used as a trap for the unwary, or to, try to, pull a fast one and use some obscure rule to, either get something done or prevent something from being done. So, yes, we use Robert's Rules of Order, and I'm going to go over some very basic Robert's Rules. But, generally, as a small board or committee, you want to make sure that everybody has a chance to speak, that they have an opportunity to express their opinions. You want to make sure that everybody is respectful of one another, is cordial to one another. You can, as former Mayor Wenham used to always say, you can disagree without being disagreeable, okay? And it is important. I mean, Wellington is a great community for a reason, and that's because we have great neighborhoods, we have great neighbors. This community is comprised of a lot of really wonderful people, and the fact that somebody doesn't agree with you does not make them a bad person, okay? Whether it's your fellow board member or whether it's a member of the public, okay? So in general, it's to be used as a guide. And it's to be used to facilitate your meeting. All right? So let's just go over some basic parliamentary rules. And I've already talked about why we use them. Okay? Let's go over the top 10 meeting rules. A quorum has to be present. Okay? So if you're a 7-member board, you need 4 members present in order to conduct your meeting, okay? All members have equal rights, equal privileges, and equal obligations, okay? Only one motion can be considered at a time. So, there's a pending motion on the floor, somebody else can't make some other motion before disposing of that current motion, okay?
Gloria, what about amending the main motion?
We're going to go over that, but yes, if there's a pending motion, someone can offer an amendment to the motion. And if the maker of the motion accepts the amendment, then the motion can be amended and seconded and voted upon. If there's a motion and a second, both the maker of the motion and the seconder of the motion have to accept the proposed amendment, and then it can be voted on. Okay? So, yes, hold on. We're going to get you the microphone.
I was going to ask, after a motion is seconded, it doesn't have to be discussion?
Yes. Typically, typically the way it's going to happen is there's going to be presentations. There may be questions. You may be asking staff members or whoever the presenter is certain questions. You may be having discussions between board members. And then someone makes a motion and someone makes a second. And then the chair typically says, any discussion on the motions. And then you can have further discussion. And then you can take certain actions. You can pass the motion. You can deny the motion. You can table the motion. You can postpone to a date certain. There are a number of actions that you can take. But yes, before the motion is made and after the motion is made, there's always room for discussion. Okay? And even after it's voted upon, you can actually go back and change it if you want to. Okay? Or if you need to. Yes, you can. So you can do a motion to reconsider. Somebody on the prevailing side can do a motion to reconsider. Okay? And I'm going to go through those basic motions because those are the ones you're going to use most often. The obscure things are just not really usable and user-friendly by small boards and committees.
Lori, we have one more question back here.
Lori, I don't know if you're going to be covering this, but is the chair the only person that could end the discussion to call the question?
No. A lot of people think that when you call the questions, anybody can call the question, okay? A lot of people think that when you call the question, you must immediately vote on the issue that's pending. That's not actually true. Calling the question means you're going to vote on the matter, okay? So we have that in here, but yes, anybody can call the question, okay? And that really is intended to cut off the debate, get moving. You've beaten it to death. Let's just move on, okay? So the president and the vice president, I mean, these are based on Robert's rules, so it's the chair and the vice chair, really. They're charged with moving the meeting forward, particularly the chair, and in the absence of the chair, the vice chair, okay? And so the chair is the person who's presiding over the meeting. If the chair can't be there for one meeting, then the vice chair is going to run the meeting, okay? The chair provides leadership, is responsible for understanding the process and procedure for the meetings, provides guidance and direction at the meetings, and encourages full and fair participation by all members of the meeting, okay? And I will tell you that if it's your staff member, if it's a meeting where either Rachel or I are present, then the chair can always look to us for guidance. If we're not there, if you're a committee where legal doesn't typically attend your meeting, your staff liaison is there to assist you if you have a question about a procedural matter or something like that, okay? The recording secretary, I'm going to skip over this because in your boards and committees, the village actually fulfills this role. Okay, so we keep the minutes and we're the custodian of the records and we maintain all the reports and things like that. So let's get into the primary motions that you're going to use. Motions are the basic tool to bring a matter before the board for its consideration. The member states, I move that, or I make a motion that, and then typically there's a second, and then as was said, discussion on the motion can occur, and then a vote. If there's no discussion, you're not obligated to discuss it, okay? As long as you've opened it up for public comment and there's nothing else to say, there's no obligation to continue to engage in discussion if everybody is, knows how they're voting. Also, certain things where there's just a consensus of, the board members, you may not necessarily need an actual vote. You may, if there's consensus to, meet on Wednesday instead of Tuesday or whatever it is, that can be done by consensus without a vote, where there's really no opposition, okay? And so typically the chair is going to want to restate the motion, make sure everybody understands what the motion is, and then ask for the vote on the motion. And usually, they'll say, okay, motion passes, 4-3, okay, or motion fails, for lack of a second. If nobody seconds the motion, it's going to fail, Here we're talking about calling the question. Again, it's a motion to end debate on a matter, and it doesn't automatically end debate. It's a standalone motion that requires a supermajority in order to end the debate, okay? And that motion is not a debatable motion. So somebody calls the question, a supermajority has to vote to end the debate, and then you vote to actually on the item that you're considering, okay? So it's a two-step process. Howard has a question.
What do you consider a
Hold on, we'll get you the microphone.
What is considered a supermajority?
Because it's cutting off people's right to express themselves. And so you want to make sure, the purpose is not to waste everybody's time if everybody knows, if people agree that there's no point in debating further. If there's not a supermajority who want to end debate, then you need to continue the debate, okay? So that's why it requires a supermajority, to make sure.
The question was, how many people constitute a supermajority?
Well, a majority of a 7-member board, right, is 4. So supermajority is going to be 2/3. So my math is not so great, but I'm thinking it's probably 5. Okay?
Okay, that's what I wanted to know.
Yeah, okay.
We have another question.
Oh, sure.
After the question is called and there's a vote, can there be further discussion?
If somebody calls a question, it's non-debatable. You're going to vote whether to end the debate. If that motion passes by a supermajority, then you're going to end discussion and vote on the matter without further debate. Okay? All right. Okay. Amending a pending motion. We talked about this earlier. Any member can offer an amendment. The member that made the motion and the member that seconded it have to accept the amendment, and then you can vote on the amended motion. Okay? You can make a motion to postpone something to a date certain. We typically do this if something is going to be postponed and has been advertised, because that costs money to advertise a particular item for public hearing. And so if you postpone it to a date certain, then the case law says and the statute says that you have fulfilled your notice requirement. You don't have to republish and reincur the expenses associated with that publication. So if you're dealing with something that's been advertised for public hearing, like typically on EPC or PCAB, then you want to postpone it, I would suggest that you postpone it to a date certain. You can also move to table something, either temporarily, or you can set a specific time. Like if you just think you need more information, you want staff to bring you some additional information, you can table it until your next meeting, or until next month, or until whenever. And so then if somebody later on decides to make a motion to bring it off the table, then you can take it back up. Okay? We just talked about this. You can make a motion to take from the table, which means to resume consideration of a motion that's been tabled. Or you can move to amend something that's been previously adopted. So you can move to modify the wording. or move to substitute a different version of the motion. Now, that's different than a motion for reconsideration, but a motion for reconsideration can be made by someone who was on the prevailing side of the issue, and it's typically proper at the next regular meeting of the board, okay? So, 6 months down the road, it's not a motion to reconsider, okay? You can raise a point of order if you think that there's been some procedural breach or something. A member can raise a point of order, and then the chair can consider whether whether there's been some violation of Robert's rules. They can consult with the staff liaison, or with counsel if we're present, and then rule on the point of order. And if there's a ruling, any two members of the board can challenge it, and by moving and seconding an appeal, and after the chair makes the ruling, and then if the appeal is approved, the chair's previous ruling is submitted to the board for a vote. Okay? This is a procedure that's almost never used, but it's a basic motion that you should be aware of. Okay? As I said before, we want you all to have opportunities to speak your mind, speak your piece, and if you're talking too much, I would expect the chair to say, okay, we're going to let somebody else speak, or we need to move the meeting along, or I understand you don't support this, other members would like to speak. So the chair really has the duty to push forward, and I know none of you are going to try to dominate the meeting. So okay. So, as I said before, things can be done by consensus if there's really no opposition to it. But obviously, if it's something that is a matter that's been publicly noticed for public hearing, is quasi-judicial, or is something like an ordinance that you're recommending, that you're going to want to take a formal vote on. Okay? But if it's some issue like when you're going to next meet, or who's going to represent the board at some particular thing, then all of that can be done by consensus. Okay? So with that said, any questions about Robert's rules, or about running the meetings, or about conducting yourself in a meeting? Okay? Any other questions about anything? Okay. Well, I'd like to thank you all for coming. I know it's a repeat for some of you, but we appreciate you being here. And I truly mean it when I say that the village values your service. We really do. And I know that the council members do. You all have been selected because you have something to add, and we thank you for that. Okay?
Thank you.
All right.
So I